This is the third segment dealing with international humanitarian law. I'm going to move on to a few other specific subjects about international humanitarian law that are of, I think, some importance and some interest. The first is prohibited weapons. We have really quite a substantial body of international humanitarian law dealing with rules governing the use and the prohibition of weapons. I've given an example earlier in an earlier segment of this presentation of the St. Petersburg Declaration, which was adopted in 1868 and which prohibited the use of hollow-tipped bullets. And that was because hollow-tipped bullets would explode inside the body of the person who was hit by them and would really cause devastating internal injuries that were entirely superfluous and unnecessary for the achievement of the military objective. And so that was widely agreed to, although hollow-tip bullets continue to be used in some contexts. Another example of a prohibition that I think was generally successful is that of poison gas. So poison gas was widely used during the First World War. We know that here in Britain that the government contemplated using it first at the very beginning, and that one of the enthusiasts for using poison gas was Churchill. The others said, no, we're not going to use it first. And they only used it in retaliation when Germany started to use it. The French used gas as well. And it had terrible effects on the soldiers who were hit by it. And many of them were, those who were not killed were permanently disabled. And so after the First World War, there was a sense that this was something that had to be entirely prohibited. And so a treaty was adopted, the 1925 Gas Protocol, which is a protocol to one of the Geneva Conventions. And but there was a lot of anxiety and a lot of unease that it would be respected when the Second World War broke out. And that's why in London and in Berlin and elsewhere, at the beginning of the Second World War, everybody had gas masks. There were millions of gas masks because people were convinced that gas would be used, and not just on the battlefield or in the trenches, but that civilians would be attacked by gas. And in fact, it didn't happen. It certainly didn't happen in Europe. There had been a little bit of use of poison gas in Ethiopia by the Italians in the 1930s, and some in China by the Japanese. But as a general proposition, the prohibition on the use of gas was very effective. But there are other prohibitions that were not nearly so effective. In 1999 at the Hague Conference, when the famous Hague Convention was adopted, there was also a prohibition on the use of aerial bombing. It was felt that aerial bombing was unfair and was not should not be permitted in armed conflict. And of course, that didn't work. And then it became clear in the Second World War that originally when the Second World War began, I think there was also a view that, yeah, aerial bombing, but targeting military objectives and not bombing of cities. And there had been a famous example of a city bombed during the Spanish Civil War in 1937, and it led to Picasso making his famous painting, Guernica, about the abusive use of aerial bombing. But at the very beginning of the Second World War, both the British and the Germans thought that it was prohibited to drop bombs on cities. But little by little, that gave way. And before the war was over, there was wholesale bombing of cities, including the final two devastating events of the Second World War, the dropping of the atomic bombs on Hiroshima and Nagasaki. We have attempts more recently to create prohibitions on weapons. So one of them is anti-personnel mines, and the other is what are called cluster munitions, which are kind of bombs that explode and create kind of a miniature minefield. And one of the concerns with these, of course, is that they get sprinkled around not just the battlefield, but they get widely used, and then they are very, very difficult to clean up after the conflict. And what happens is little children go out and start playing with them and find these colorful pieces of plastic and blow their hands and legs off if it doesn't kill them. One of the weapons that ought to be entirely prohibited, but is not, is nuclear weapons. And the advisory opinion of the International Court of Justice in 1996 reminded the nuclear states that there was an undertaking under what's called the Non-Proliferation Treaty. There are a number of treaties dealing with nuclear weapons under the Non-Proliferation Treaty that they were to disarm, that they could have a monopoly on nuclear weapons, that no new countries could get them, but on the condition that they worked towards full disarmament. Of course, they haven't done that. And some years ago, a treaty was negotiated that only entered into force in October of 2020, which is an anti-nuclear weapon treaty. It has 50 states that have ratified it, and that's great. But the most important ones are the 8 states that have nuclear weapons, and they still have them, and they're not giving them up. So this is a great gap, a great failing in international law. Let me move on. I have a few other points. I realize I may have gone on a little too long. I mentioned the Geneva Conventions. They have a concept that is important in international humanitarian law of what we call protected persons. So they identify different categories of individuals for protection, and therefore they're called protected persons: civilians, prisoners of war, and wounded combatants. And that's why we have the 4 conventions. For the wounded combatants, we distinguish between war on land and war on sea. And then the 3rd convention, prisoners of war, and the 4th convention, civilians. There are important rules that apply to occupied territory. There aren't a lot of occupied territories in the world, but there are a few, and they've been occupied for a long time. So I think the most notorious of them is the occupied Palestinian territory, the West Bank and Gaza, which have been occupied by Israel. Gaza is not technically occupied, except that Israel has totally controls it. So it is really, in practice, a form of occupation since the war in 1967. Occupation is supposed to be temporary. Now we're into the jus ad bellum. But when the territory is occupied, there are a whole range of rules that have to apply. One of the most important, and one that has been systematically violated in the occupied Palestinian territory of the West Bank, is the prohibition of the transfer of populations into the territory that's been occupied. And Israel has managed to create, over the last half century, what is really amounts to a fait accompli by moving settlers into the Palestinian territory in violation of international law. And until very recently, virtually every country in the world was prepared to condemn Israel for this practice, including the United States. But under the Trump administration, about a year or so ago, they changed their position and now seem to be encouraging and giving the blessing to Israel to continue to develop new settlements and to eventually annex the parts that are the settlements where they've already moved settlers into the occupied territory. Finally, just a word about an interesting and important dimension of international humanitarian law, which is the protection of cultural property. And there are specific rules prohibiting both the attacks and the destruction. Attack would be in the conduct of hostilities on the battlefield, and destruction would be the territory you control. And of course, in an international armed conflict, both the attacks and the destruction are entirely prohibited. I'm not so sure that the destruction is prohibited in a non-international armed conflict. Cultural property is an interesting problem because there are some things that are considered cultural property that are controversial. So if we had some people who in Bristol tore down a statue earlier in 2020 and dumped it in the harbor. This was a part of the Black Lives Matter movement, and it was a statement really that statues that glorified slave traders ultimately glorified racism and shouldn't be there, and they went and tore that down. Is that a cultural monument? Some people would argue that it is, but I would take the view that, well, not all cultural monuments then are protected. Because culture, of course, one person's culture is another person's atrocity. And we have monuments and cultural things that can arguably claim to be cultural in that sense, or historical, that all they do is commemorate atrocities and individuals who were responsible for atrocities, and maybe they shouldn't be there. This is part of the complexity of the protection of cultural property. I think in an international armed conflict, we'd say you can't decide to destroy the cultural property of the occupied territory, because that's for the people there to decide. But when you have a civil war and one side takes over half the country, it seems to me they should have the right to take certain decisions about whether they want certain monuments to be preserved and protected. And we can debate that in the classroom. Thank you very much.